I'm testifying on behalf of the Capitol Hill Restoration Society, the largest civic organization on Capitol Hill. And since 1955, we've advocated for the welfare of the Capitol Hill community. Telecommunications companies plan to install 2,500 to 2,700 small cells in this city during the next 5 years. This raises many serious health and environmental issues. I would like to focus on just one issue: limiting the number of poles needed, or the number of junk, as was mentioned, on our streets. In public meetings, residents said that they fear the proliferation of small cells and the poles because DDOT's draft guidelines potentially allow each of the 4 carriers to each place its own pole on a block, resulting in a potential of 4 poles on one block. Not just one pole. There is a means that already exists to mitigate this proliferation of these poles. And it's called colocation. Another word for this is hoteling of small cell facilities. This means basically that the small cells of different carriers would be on the same pole. Crown Castle will be hoteling for 2 carriers. I understand that they can accommodate a 3rd carrier, and this is already possible. Colocation offers important benefits in reducing clutter, or junk, as it's been called, helping to preserve view sheds, and reducing the risk to street trees. But DDOT's draft guidelines are very deficient in this respect. They never define colocation, and they never mandate colocation when colocation is technically feasible. Whereas we believe that it should be defined, and the Nashville ordinance defines it, and it has detailed rules on when colocation would be feasible. So a lot of the drafting has been done. It can basically be reviewed by DDOT's and Octo's lawyers. Technology changes very rapidly, and even if colocation is not feasible today, the master licensing agreement has a potential term of 20 years, and at some point during that 20-year time, colocation may become possible. DDOT's response to this at public meetings has been, well, it's possible to have colocation under our guidelines, but it is never defined or mandated where it's feasible. DDOT has also said, well, at some point, all of these locations on the streets will become very scarce and hard to get, and therefore, under sort of a law of the jungle, my word, not theirs, carriers will be forced to do hoteling because basically they'll be running out of spaces. We believe the responsible practice would be for DDOT to mandate colocation now, manage this process, and where it's feasible, do it. For example, just briefly, the Nashville one basically requires if a carrier comes in and wants to install a small cell facility, if it's co-located, that would be good, and it should go right through. But if it's not co-located, the Nashville ordinance basically says, you need to testify, explain to us why it's not feasible. Show us that it's impossible.
I don't mean to interrupt,
Yes.
but I'm following along. And I'm mishearing, you're saying the Nashville ordinance.
Yes.
Okay, fine.
In other words, someone who faced this issue earlier in time than we have faced this here, basically sort of provided some approaches that might be useful. And basically, either you have co-location and you comply, or in very detailed terms, you explain why it's not possible. So as I mentioned, Crown Castle has said at public meetings they will be co-locating Sprint and T-Mobile's small cells. We understand that in Ocean City, Maryland, all 4 carriers on the boardwalk have co-located. We also understand that while AT&T, Verizon have stated they will not co-locate in Washington, we understand they do co-locate in other cities. We also checked the FCC's September 26 order, which is reproduced in part in a footnote in our testimony. And we believe that requiring co-location where it is technically feasible is consistent with the FCC's current order. So there's no reason why we cannot have this benefit in Washington. So for these reasons, we advocate modifying the draft design guidelines to define co-location and mandate it where it is technically feasible. Thank you for considering our views.
Thank you very much. Mr. Hanson?
Good afternoon. Stephen Hanson, Chair of the Committee of 100 on the Federal City, and I thank you for this opportunity to testify today. With the proposed small cell rollout in the district, thousands of units are expected to be installed across the city, raising major issues of clutter and effects on view sheds, the monumental core, historic districts, all neighborhoods, tree canopies, and public health. In light of a pending 5G rollout, we are currently attempting to address two technologies simultaneously: expanded 4G and eventually 5G, whatever that will ultimately look like. 5G doesn't exist yet, and there's no single standard or judgment currently determining what it will be. Mostly, it's the individual marketing departments at carriers and vendors that are selling us on the 5G concept. This 5G marketing engine is now in full tilt. The problem is that this is all way ahead of where the technology actually is. So what we're dealing with now is simply expanding current 4G coverage into the narrowband Internet of Things. Under the guise of 5G, what the DDOT draft design guidelines address is beachheading or establishing footholds for expanded 4G now and as a placeholder for the arrival of 5G. When 5G does arrive, carriers will then return with additional 5G cells, and at this point we don't actually know what they'll look like. It could be a combination of canisters, panels, or donut-shaped antennas, all without the required further design review. The 4G antennas will stay in place. In addition, we're also looking at the octo or the DC Wi-Fi antennas on these installations. These 3-foot-long antennas need to be attached to each pole only 15 feet off the ground, and are not covered in the draft design guidelines. With a still unknown number of installations and number of new poles, antennas for both 4 and 5G and octo, the supporting hardware and wires, we are potentially looking at a mess across the city. Let's look at some of the issues that the carriers had during the Public Space Committee hearing with the draft design guidelines. There came out that AT&T and Verizon won't hotel or share poles, claiming technical incompatibilities. AT&T wants more poles, additional pole height, has issues with the one carrier per block limit, and has problems with putting cells in alleyways. Crown Castle finds the guidelines inflexible, wants looser hardware restrictions, strand mounting, which is suspending antennas off of cables run between poles, and has concerns with vaulting, that is, placing the support equipment underground. Verizon also refuses to vault, has issues with the 20-foot limit from landmarks, and therefore wants to remove the federal property restrictions. This will have a very negative effect on our landmark buildings and historic districts. Mobility also prefers not to vault and wants to put cells in other types of poles as well. It is clear that the draft guidelines do not work for the carriers, but if they are given what they want or claim they need, there will be no uniform standards for implementation and will be guaranteed a mess. We're concerned that DC officials are falling back on the 1984 Chevron Supreme Court ruling that allowed for administrative deference to a government agency's interpretation of a statute which it administers for the reason for not challenging this FCC order. Yet the Chevron ruling is not having such a chilling effect on a growing number of municipalities that are pushing back and slowing the process to address the needs of their communities. Among these are Marin County in California, where officials have joined other governments in challenging the FCC order. Seattle, Washington is challenging the FCC order as an overreach by the federal government, stating that it impedes local authority to serve as trustees of public property, fulfill the city's mission to protect public health and safety. Santa Rosa, California recently put small cell deployment on hold there, partly because residents there were upset at the size and proximity of the small cells to their homes. Nashville, Tennessee's City Council passed an ordinance requiring that the telecommunications industry comply with building codes and other federal regulations, including Section 106 of the National Historic Preservation Act. We cannot and should not rush this process. It needs more time, careful study, transparency, public awareness, and engagement. Also, a significant number of ANCs have sent resolutions to the Public Space Committee expressing their concerns about the process. Committee 100 is in support of the National Capital Planning Commission and the Commission of Fine Arts requests that DDOT work with them to convene a meeting with carriers and industrial designers to develop a unified design typology for poles and related equipment. We ask that DDOT explore hoteling and require carriers to document why that is technically not possible. We also call for a pilot study within a designated area of the city where all 4 carriers deploying the equipment in a manner they claim is necessary to see what we may be facing for a citywide rollout. Thank you.
Thank you very much. Ms. Pauls, am I saying that right? Pauls? Pauls.
Thank you very much for convening this hearing. My name is Cynthia Pauls, and I'm in this issue in part from the historic district perspective, as I live in Adams Morgan, and my immediate neighborhood is a historic part of the historic district. Sort of as a prelude, I'd like to say that 5G has all kinds of promise, but it's technically very complex, and it's going to be very costly for everyone. And it's technically so complex that I think we're quite far away from actual deployment. So we're kind of setting these rules without really knowing what it is we're setting the rules for. So we don't really know how tall their poles need to be or whether they can be on roofs, etc. But at the same time, we have to recognize that if 5G does what its proponents say it will do, it's a pretty revolutionary technology, so it is important. So from that perspective, that broader policy, we need to be careful too. I mean, if it's as powerful as they say, it will replace much of what we now have as wireless and wireline industries, because it will do what cable does, only more efficiently and better. They talk a lot about how it's really an important aspect of the self-driving car movement. If you look at the projections on where it's going to have the greatest impact, that's usually what's cited. But you know, there are these technical and cost barriers. It's not going to happen anytime soon. And I want to talk a little bit about the FCC role and things. The District of Columbia actually is a party to, with a group of municipalities seeking a stay of that decision, so it's not a done deal. And there's, I assume it's also going to be a party to the appeal that's going to follow. There's a lot of issues of overreach on the part of the FCC where much of what's in that decision is, I think, vulnerable to being struck down. In other words, I think we should take the time to get it right, both from the technical perspective of the 5G and the legal environment. I was pretty troubled by the whole way in which this whole business came to be with the secretly negotiated master license agreements that are going to run for 20 years. It really doesn't seem the right way to be doing business. I don't see that the documents that the district has come up with are firmly rooted in BC statutes or regulations. There's a statute, you know, that gives the mayor vague authority over public rights of way, but that's all that it says. There's nothing that talks about small cells. It just seems something as monumental as this, the district should actually, the council should provide some guidance to the agency so that there's directives on policy and that they're doing what we want them to do. At the same token, I wouldn't say it's really obvious to me just yet exactly what those policies should be. I can tick through the master license agreements and the design guidelines and identify many, many flaws and tell you that it's just terrible that they're going to propose to allow these very tall poles to proliferate in my neighborhood, where the poles are those really pretty Washington Globe poles. They're like 14 feet tall. If you spin through the way these height things work, we could end up with poles as tall as 41 feet on my street because you get an extra 10 feet under the FCC rules if they stand. So we give them 31, they get 41 automatically. So we have 14-foot poles and possibly 41-foot poles from these small cell providers, an equal number to the number of poles that we have.
I'm going to have to interrupt you there. Your time is up, and we have your testimony. It's quite lengthy. There's no way you're going to possibly be able to go through it.
I'm not reading my testimony.
I'm just saying, so we will have it. In any case, if you could just sum up.
Well, the sum up is very simple. There's a long list of problems with the design guidelines and the MLAs that I've documented for you in more detail, and I won't go through them. I just think we need to do a pause on this process, that the council needs to get involved, that there needs to be some direction, there needs to be some consideration of what it is we want 5G to do for us, that we shouldn't just sit here and passively accept notions from the industry that we have to get authority, we're going to do all these great things, without us saying to them, well, this is kind of the way we'd like things to happen. That's the kind of process that I think. We've got it backwards, where the agencies met with the industry and came up with these documents, these guiding documents, when really the policymaker should say, this is what we'd like to accomplish. So that's all I would encourage is, it could be a great technology, but we should shape it and define it so that it meets our needs as opposed to whatever it is the industry wants to do.